My name is Mohammed Abdulaziz, and we'll start with the issues. Galleon, a large property owner, leased a part of commercial center to Kalila. Kalila contract Bloomberg to carry out certain works within the leased property. The both lease contract between Kalila and Galleon, and the contract between Kalila and Bloomberg are governed by English law and contain arbitration clause. Bloomberg was made some damage and part of the commercial center become unusable due to this fault. Galleon claimed 10 million losses against Kalila. Kalila settled the claim for 3.8 million before the arbitration was concluded, and consequently, Kalila raised the arbitration against Bloomberg for these defective works with the same amount, 3.8 million loss incurred by Kalila to Galleon. Bloomberg demanded Kalila share detail for the relevant material so that they can check for the basis of these estimates to test the amount Kalila claimed against him. And Kalila insists the previous arbitration proceeding between them and Galleon were confidential. Bloomberg applied to arbitrator for permission to go to court and seek disclosure of the Galleon-Kalila arbitration materials. And I hereby choose to represent Bloomberg in supporting their demands. First of all, I would like to talk about some of the arbitration advantages against litigation, like efficient and flexible, as a quick resolution, easier to schedule, and it less complicated, simplified rule of evidence and procedure. Impartiality, as both parties can choose their judge. Usually less expensive most of time, but not always the case. Finality, at the end of the dispute, come with the end of the final word or award from the arbitrator. Privacy, as it keeps out of the public eye, unlike trial arbitration leads to a private resolution, so the information brought up in the dispute and resolution can keep it confidential. Although the other party in the arbitration, Kalila, uses advantage confidentiality as a strong point in supporting his demand, the 3.8 million claim from the previous arbitration, without any detailed supportive material, and considered as a weak point for me as a room-making client. I would like to talk in detail about confidentiality in arbitration and the cases of disclosure. Confidentiality is viewed as a cornerstone of English arbitration and one of the main reasons commercial parties often opt for arbitration over court proceeding for the resolution of their disputes. And the English court have taken a strict approach when enforcing the confidentiality of arbitration, and the parties should be careful to avoid breaching the general duty of confidentiality. However, the duty is not absolute, and the disclosure would fall within an exception and will be permitted to disclose the detail of arbitration. And if we need to disclose the confidentiality obligation in arbitration, we should keep in mind the following points. First point, the underlying contract. Most of contract will not contain a specific confidentiality provision relating to arbitral proceeding, but may well include general provision on confidentiality. And the next point, arbitration agreement. And third point, the arbitration rules, since both arbitration clauses provide that the dispute will be resolved in accordance with the CIRB arbitration rules 2015. In CIRB arbitration rules 2015, rule number 12 provided that any confidentiality or trade secret concerns that will require a particular measure to protect confidential or proprietary information. The rule doesn't provide sufficient details, and there are no exceptions to it. And I admit that this rule in the CIR consider a weak point in my submission. However, the next point of the next point is one of my strength point in my argument. But before we're talking about the next point, common law obligation, I would like to highlight the Law Commission of England and Wales proposal. As in September 22, the Law Commission of England and Wales launched a consultation review whether the legislative framework governing arbitration in England and Wales, the Arbitration Act 1996, should be amended, and the proposed updates in some arbitration features like confidentiality, independence and impartiality, immunity, and discrimination. Regarding the confidentiality feature, the conclusion of the Commission is that one-size-fits-all approach will not work. A key issue is developing and codifying exceptions to the rule with a statute, but the court found it difficult to identify the appropriate exception to confidentiality. Statutory law is more rigid. As a result, the Commission proposes that the English court continue develop confidentiality principles through the case law and apply them in the context of specific fact of each case. Next, the strong point, I will start to talk in common law obligation. Common law obligation, generally speaking, the Arbitration Act 1996 doesn't include any express provision as to the confidentiality because the drafters consider this was better left by the court to resolve on a case-by-case basis. Okay. Then we will start with the English Commercial Court case Hasni Insurance Company of Israel versus Stewart G. Examine the issue further. The case concerned the ability of a party to arbitration to disclose the currently published arbitral award in another legal process against the third party to justify the claim and to research the potential of of the settlement before the commencement of the process. It was considered that at later stages of the court proceeding, the party would require disclosure of the other arbitration documents such as transcript, pleading, and witness statement. Also, the court reaffirmed its decision in Doling Baker that the specified categories of document are subject to an implied obligation of confidentiality. It also acknowledged an additional exception to the confidentiality rule that it was permissible to disclose an arbitral award if it was unavoidable in order to bring an action against a third party. Although in Ali Shipping Corporation v. Shipyard Tugir 1999, the Court of Appeal upheld an injunction restraining the yard from the disclosing material from the first arbitration in the later arbitration because the disclosure was not reasonably necessary for the yard to make it the case on the merits, but it would simply have saved time and expense. But the Court of Appeal in this case set out this exception clearly. They set out 5 exceptions to disclose the confidentiality. First one is the party's consent, expressed or implied. Second, where there is an order or permission of the court. Third, where it is reasonably necessary for the protection of the legitimate interest of an arbitration party. Fourth, the interest of justice required disclosure. 5, the public interest. And I hereby use the fourth exception, the interest of justice, to ask for disclosure of the detailed material of Kalon Kalila arbitration to allow Rosenberg to assess the merit of the party's position in that arbitration. And to illustrate we need exception in such cases, I want to suggest in your mind, Mr. Arbitrator, scenario. We will assume that you refuse to give me a permission to go to court and seek disclosure of the Kalon Kalila arbitration materials. Okay? and I have started assessing the actual cost for defective works incurred by my client Nuremberg in details. And let's say the total amount of this defective work 1.8 million. And I want you to bear in your mind the first arbitration galleon property owner was claiming was 10 million, okay, and for this defective workers, and during the arbitral proceeding for the first arbitration was made a settlement with Karela. This number reduced by 3.8 million. This means the number claimed reduced by 62%. In this scenario, you have now in your hand as an arbitrator in arbitration proceeding a settlement from Kalila without any details from the first arbitration and any supportive document with a value 3.8 million. And then the other hand, detailed assessment of the defective work produced by Ruenberg, by me as a Ruenberg client, with amount 1.8 million, for example. Okay. How will you arbitrate in such case? If your final award is the Kalila settlement amount for from the first arbitration 3.8 million, it goes without saying I will challenge this award in the Court of Appeal under Section 68 of the Arbitration Act 1996, challenging the award, serious irregularity, point 2F, uncertainty or ambiguity as to the effect of the award. In such a scenario, we lost at least four of the most advantage of the arbitration process, efficient and flexible, as it, arbitration quick resolution, as either, but in this case, either me and Karila might not satisfy with your award and will challenge it, so we will lose this one. Less complicated, it become now more complicated because the, from the beginning we know someone will going to challenge the award. Most of time, arbitration is less expensive, but not this time. Finality, we will not achieve, most probably me or Kalila, me for sure, will challenge you. Okay. Also, as an arbitrator, your judge will lack clarity, as you might miss due to the mysterious, confidential, missing document, some detailed facts, and also the rationality and logically. And you have a rigid award from the previous without any detail, so you can't give the rationality logically to this award. If you count it, your award will be the 3.8 million. Certainty and or validity, as it will lack sense of rights, fullness and accuracy of sure. Finally, and after all evidence I derived for you above, I ask for permission to go to court and seek disclosure of the not trade secret Galleon Kalila arbitration material. Thank you.